Welcome to Embargoed, a podcast featuring intelligent talk about sanctions, export controls, international trade, and for this week at least, seditious conspiracy for trade nerds and normal human beings alike. I am one of your hosts, Brian Fleming, and I am joined, as always, by my good friend, colleague, and co-host, Mr. Tim O'Toole. Tim, how you feeling? How you feeling on this January 8th, 2021, 2 days removed from the events that we're going to talk about in a minute at the Capitol? How you feeling?
2 days post riot, I'm feeling pretty good. Happy to be on a podcast and not to be walking around Capitol Hill, which was much more eventful than it normally is. It's pretty sleepy in this neighborhood usually.
Yeah, Tim's our man on the scene to give us real firsthand insight into what happened the other day at the Capitol. But we'll get all that in a minute. So welcome as always to all of you. Happy New Year. This is our first pod of 2021 after having put up a couple last month at the end of the year. We're like everybody else, I think, in the world, very happy to welcome 2021, and then of course promptly have been punched in the face here in the first week of the new year. So we're gonna talk about all that in a moment. But thank you to everybody again for joining us. As always, it's a pleasure to be here with you. So we have a lot to cover today for our first episode, so we're gonna get right to it in a moment. As always, the normal disclaimer, we're not providing anyone with legal advice. We're not talking about any confidential information on the podcast. The opinions that you are about to hear are entirely mine and Tim's. They're nobody else's. If you do enjoy the pod, if you are a regular listener or a first-time listener and you like the pod, please subscribe. You can find us anywhere: Apple, Spotify, Google, Stitcher, Overcast, YouTube, wherever you get your content. Please subscribe. Please give us a rating, hopefully a 5-star rating. So let me run through very quickly what we're going to cover today, and then we will jump right in because as a result of the events of a couple days ago, I think we have an initial segment that we hadn't probably been planning to do that we're going to cover here for a few minutes before we get in. So the roadmap of the episode generally is as follows. So we're going to start with the new executive order that was just issued earlier this week, targeting Chinese apps, in particular AliPay, WeChat Pay, and a number of other apps. We're going to talk about that, what that means, whether that's going to stick around in the new administration. We're going to talk about the military and user list, which is no longer a phantom list. It is a real list that has now been issued since we spent a bunch of time talking about it a couple episodes ago. We're going to talk about the latest guidance on the executive order targeting publicly traded securities and Chinese military companies. There's some new guidance on that came out in the last couple weeks. So we're going to talk about that in advance of January 11th, which is a key date under that executive order. And then we're going to finish up with the individual who, at least formerly, I don't know if he still currently does work for Ethereum, and had traveled to North Korea and has been charged with conspiring to evade sanctions in connection with some training that he did or a presentation that he gave while in North Korea. His case is moving along in SDNY. We haven't talked about it since shortly after he was arrested. I think there's some interesting things that have bubbled up there, so we're going to talk about that for a minute. And then in the lightning round, we're going to cover two topics. We're going to talk about a preliminary injunction that was just issued in SDNY also relating to the ICC executive order. We talked about that litigation a couple months ago, so we're going to check in there to look at that preliminary injunction. And then we're going to talk about the newly expanded Nord Stream 2 sanctions that were just put into effect after the National Defense Authorization Act was finally passed a few days ago. And that'll be our episode. But before we do that, we are going to talk a bit about what happened at the Capitol on Wednesday. We're recording this on Friday, January 8th. Wednesday, January 6th, of course, I think is a day that I think is going to live in infamy in U.S. history without much question. And of course, for anybody who is not aware of this, who maybe is outside the US, not following this, although it's hard to imagine anybody is not aware of this at this point, after a rally and a speech by President Trump where he encouraged the angry mob of his supporters to essentially storm Congress, that's exactly what happened. People have been, and of course now a couple days later, 5 people dead as a result of that. One of the mob members, and then I believe four Capitol Police and other people who were just on the scene from unrelated incidents. It took hours to clear the scene. Of course, this all happened in the middle of the normally very routine formal acceptance of the Electoral College vote to officially certify Joe Biden as the next president of the United States to be inaugurated in 2 weeks. And that was sort of the inciting event for the rally and the actions that took place. And so, I think, again, because this is a podcast that focuses on national security issues and the rule of law, we felt like we have no choice but to talk about this, just like everybody in the United States, I think, kind of feels the same at the moment. So I'll just start very briefly and then throw it to Tim. I was for a number of years, as many of you know, a national security prosecutor at the Justice Department. And when I joined, or shortly after I joined, we all received a little blue handbook that essentially contains all of the statutes and that we were tasked with enforcing and investigating, and that covers everything from the types of matters that we talk about, the big section on IEPA and sanctions and export controls, et cetera, um, terrorism-related statutes, all those types of things that you would expect. There was also a section in the manual, in the book, the handbook, that dealt with treason, rebellion, insurrection, seditious conspiracy. These are, make no mistake, they are federal crimes if you're not aware of that. They're in the US Code. I think the very first time I noticed that, I looked at it a bit as a curiosity. The only time I can ever recall seriously, looking at that portion of the handbook related to a former member of the U.S. military who was being investigated for potentially selling state secrets to a foreign adversary. And there was some discussion about whether the elements of treason had been met with respect to that individual. That is the only time I ever looked at it. Never in my wildest dreams did I ever think that there would be serious discussions going on now in the public sphere and presumably within the Justice Department as to whether or not the United States president, the sitting US president, should potentially be charged with one of those crimes. It is, I think, sadly not surprising that this is the way this administration is concluding, but it is shocking. It is personally shocking to me. And it is, again, we talked about this a bit over the summer when we were talking about the protests against police brutality and racial justice, and for racial justice after the George Floyd and other events that led to that. So much of what we talk about and what U.S. policy is premised on in the area that we focus on is rooted in things like ensuring and, quite frankly, penalizing others around the world for not having free and fair elections, for not respecting human rights. These are central pillars of our foreign policy in the United States. And as we have asked before, I'd sort of just throw this question open to the listeners, to Tim. How much has that been eroded by what has happened this week and over the last 4 years? How much does that, frankly, compromise or jeopardize the US's ability to seriously enforce these laws that we talk about literally every day amongst ourselves, with our clients who are fearful of the power and the might of the U.S. government coming after them for violating these laws? And here we are left to watch what unfolded on Wednesday and think, how can these things compute? How can something so antithetical, so hypocritical, so shockingly dissonant from that underlying message be allowed sort of to to go by or to stand, or how do you reconcile those things? And I don't have answers to that. I'm just these are the things that I have been thinking about and that I wanted to put out there. And with that, I'll throw it to Tim to add a few words there.
Yeah, I never expected to be talking about this topic in my lifetime. Certainly not in connection with an attempt to storm by force the United States Capitol with the intention of preventing the execution of a law, namely the constitutional act of certifying the Electoral College. It just seems shocking to me, and I can't believe that it happened, in the United States in 2021. And just when you thought 2020 was bad, you wake up in 2021, and I think probably the most consequential event of the Trump administration, quite honestly. I do think, as I've pondered this, there's very little from the last 4 years, I think, that will be remembered 100 years from now, but this will be remembered 100 years from now. As long as there is a United States, it will be remembered that a mob stormed the Capitol to prevent the counting of votes that was instigated by an incumbent president. You can't even imagine such a thing happening. And to your point, Brian, it really is something that, from a sanctions standpoint, if a government in another country did this, the U.S. likely would and has, in the fact, imposed sanctions on leaders and on groups that have done exactly this.
There would be new designations. There would be a new executive order being drafted as we speak if this happened in certain countries in Latin America or Africa or
anywhere around
Asia
the world.
or anywhere. Yeah, absolutely.
Can you imagine if, let's say, a group did the same thing to the UK Parliament? That group, and imagine if Boris Johnson instigated that sort of thing. I mean, you can't, to say it is almost laughable, because you can't imagine it happening in a developed democracy, and yet it happened in the world's oldest developed democracy. What used to be considered, quote, the leader of the free world is now just it's certainly something that is no longer, it's moved from the kind of the rhetoric to reality, and I think it's very disappointing and very shocking. I mean, I do want to, in terms of what this means, for national security, for sanctions, I will say that I was, although the whole sequence of events was disappointing, the way that our country has responded to it so far has given me some optimism. We did get to the brink, and I can't believe we got to this point, but it does seem like many of our institutions held and seem to have prevented in what, I think was an appropriate, but certainly not necessarily consistent with the chain of command type way, having intervened and really brought this crisis hopefully to a close. The reason I say that is, at least if the reports are that this was ended because the Secretary of Defense, in consultation with Vice President Pence and the leaders of Congress on both sides of the aisle, determined that the National Guard should be sent in, at least according to the reports I've read, after the president refused to do that and actually blocked it. And in our chain of command, once the president says that, you don't normally then go down the ladder to somebody else who will actually do the right thing. That did happen, and I think it appropriate, because I do think that, to the extent that the president refused to intervene in this, if that's true, that was an illegal order. It was an unconstitutional act in and of itself. And so you can make the case that the resulting order was legal, and that our institutions stepped in to protect it. But the fact that we had to get there, and the fact that you would be having an argument about whether it was legal for the vice president to countermand an unlawful order of the president that had been preceded by what many are calling incitement of an attempt to overthrow a lawful process in the United States Congress by the sitting president. I mean, it's really, we've called these interesting times. We're in month 9 or 10 of a global pandemic. We had the president was impeached almost exactly a year ago for things that were also troubling, but not anything approaching this nature of troubling. And it's just hard to believe we're here. And I hope we get out of it, and we get out of it quickly. But I think people will be talking about this 100 years from now and maybe 500 years from now.
Yeah, agreed. So I think that's all we really wanted to. We felt like we had to start there because it's just something that can't be ignored. So those are I agree with everything Tim said as well. And while I think he's right that our institutions perhaps prevented a far worse outcome here, and there might be some reason for some optimism. There's also a lot of reason to continue to be concerned even after Inauguration Day. So I don't think
Yeah.
anybody should be under any illusions that this is something that just goes away magically once there's a new administration.
I,
So
I also
in any event,
I
go
also
ahead.
did want to say, I mean, I got a lot of people know that I live very close to the Capitol, on Capitol Hill, and I got a lot of calls and emails and texts from people, both in this country and around the world. And I want to say I really appreciate that, and it was a surreal experience to be only a few blocks away from what was going on, and in some ways, a little made it a little bit scarier because there definitely were people who were part of this that were basically walking by my house on the way to and from it. So it was both a personally weird experience, but also just from a an American, just a an experience that nobody ever thought they would see.
Agreed there. So with that, our somber opening to 2021, as we the title of this episode, by the way, which you will all be seeing at this point, is Trump's parting shots at democracy and China. Two, I think, of his, if there are lasting legacies, I think that's what they will both be. And so let's pivot now to China, which is obviously the thing that we spend the majority of our time talking about on this podcast over the last year. So let's just go right into item number one, which is as I said earlier, a new executive order that was just issued early this week. It is in form quite similar to what we saw issued in August with respect to WeChat and TikTok. It is titled an executive order addressing the threat posed by applications and other software developed or controlled by Chinese companies. Again, this is the sort of the preamble here, and the justification for this is again U.S. data security and data privacy considerations. Again, very similar to TikTok and WeChat, and the sort of mechanisms that this will be by which this will be implemented, at least on the face of the executive order, are largely the same. The prohibitions don't go into effect until 45 days after issuance of the order, which is February 19th. And the Secretary of Commerce is again charged with defining and identifying what the specific prohibited transactions are going to be pursuant to the order. I will read sort of one snippet here and then make a couple comments, and I'll throw it to Tim. So again, this is targeting U.S. persons subject to the jurisdiction of the U.S., and the prohibitions will extend to any transaction with persons that develop or control the following Chinese connected software applications or with their subsidiaries, as those transactions and persons are identified by the Secretary of Commerce. And they are AliPay, Cam Scanner, QQ Wallet, ShareIt, Tencent QQ, VMate, WeChat Pay, and WPS Office. So that's a pretty wide array, including some very big players there. Obviously, AliPay and Ant, WeChat Pay. We've talked about Tencent. Some very major companies that are implicated there, and some applications that are very widely used, certainly in China, but also in the U.S. and around the world. So I think here's kind of the couple of just quick thoughts on this to throw over to you to respond to and to consider. So number one, we know, obviously, given the track record of the WeChat and TikTok EOs, both of which are not in effect at the moment due to multiple preliminary injunctions that were based on a variety of IEPA related grounds in terms of the information materials, personal communications, carve-outs, the Berman Amendments, and First Amendment grounds. And primarily, those are sort of the two bases. So clearly, I think if these prohibitions are going to move forward, we're going to see more court challenges. We're going to see things that are going to mirror and mimic what we've already seen be successful in these prior challenges. Now, I think the one question here is that the nature of the apps and the software that's in play here, not exactly as squarely within kind of the traditional communications First Amendment kind of bucket. Some of them are to some degree, but some of them, like the payments apps, are arguably just commercial, right? Just for commercial purposes. There's no speech. There's no, so, I think that puts these in, and again, there's among the apps that I read and that I read off that are part of the order, it varies. So it could depend on who would bring a challenge, and it may not be possible to sort of perhaps block the entire suite of these from going into effect, but at least some of them I think would be susceptible to similar challenges. So that'll be interesting to see how that may play out. The other big question and thing to bear in mind is this is coming barely 2 weeks before the end of the administration. It doesn't go into effect for 45 days. So the Biden administration and his incoming Secretary of Commerce, or actually the acting Secretary of Commerce after he takes over, and that team are going to inherit this. I have a very hard time believing that this is one that they're going to let just sort of play out. I think there's a very high likelihood this gets rescinded or modified substantially, or at least shelved for some indefinite period of time while they consider how they might want to deal with these issues. Again, the underlying issues are well understood and I think, widely agreed to be problems, national security problems, not controversial at all, but the means and the mechanism of achieving that, I think, is somewhat controversial and is in dispute. And as evidenced by the way that the WeChat and TikTok orders were attempted to be implemented, which is to say that they were not allowed to be, given the way those were handled and the way they were drafted and the way the prohibitions were put together. I think there's a very good chance that these things are going to get kind of put on ice once the new administration takes over. So just on that front, I guess, what are your kind of initial reactions?
So I'm going to harken back to what we talked about at the beginning of the program in a second, but I think that it really is important to understand that these things are not be viewed in a vacuum. You can't look at them in a vacuum. This is another act by the Trump administration as it widens down. And this is not unusual to any administration that is leaving office. You try to lock in some of your policies and make them hard for your successor to undo, particularly if your successor is from a different political party. And so, this is of a piece with a lot of actions that we'll talk about today and that we talked about at the end of last year, where the Trump administration is trying to lock in some of its policies with respect to China. And I do think that, when you read that executive order, there's many things in it that the Biden administration, I think the national security people there would agree with, that the threat from the Chinese government collection of data on US citizens is not a partisan issue. And I think there's concern on both sides of the aisle about it. And I think that was what this order was nominally designed to address. But I do think that that the timing of it and kind of the weird nature, I was going to say unprecedented, but that's too legal a word. It's just weird that they're doing this to certain apps that they've identified right at the end of the administration. But I think it's one of those things that in a vacuum would be hard for a predecessor coming into office to undo without some political fallout. I think that the events of this week have actually made it much easier for a President Biden to undo almost anything President Trump did in the last few weeks. I mean, I think everything that he touches right now is going to be viewed as suspect and make it easier to undo, and that the politics of undoing it will be a lot easier. I mean, I'm not a political theorist or a political expert, but I do think from just a political standpoint, it might have been hard if this was just viewed as a policy issue for President Biden to come in and say, no, we're undoing this because we're not concerned about Chinese collection of U.S. persons, confidential private data. But it will be a lot easier now to say, hey, this was 2 days after there was this riot at the Capitol that was, by all reports, instigated by President Trump. We're undoing anything we feel like undoing with respect to that because it's all viewed as suspect. So I agree with you. Ultimately, this is likely not to take effect in the form that is in this executive order, and nothing like it may ever take effect at all. Although I do think that this executive order did a much better job than the WeChat order or the TikTok orders of actually trying to come up with a justification that might pass the laugh test, because it's not really regulating speech in the way that those orders were doing, and it seems to be tied to a legitimate problem. Now, whether or not there's any evidence that these apps in particular were the source of that problem, I don't know, but it seems like a much the legal case against these restrictions, I think, would be more difficult than the ones in TikTok and WeChat. And so if this were to go to litigation, I'm not sure that you'd see the same sort of result, but I think this may never get to litigation because politically it will be much easier for the Biden administration to undo than it would have been if you had a President Trump who was spending his last 2 months in office really focusing on his policy agenda, and everyone was convinced that this was a real policy choice, which it may well have been. President Trump may have had nothing to do with this, but I do think that things that happen in this period of time are going to be very suspect if they're coming from the Trump administration right now.
Yeah, I agree with all that, and I would just say a couple final thoughts, which is this issue in particular, even before the events of this week, is so, I think, closely tied to President Trump himself, the rhetoric that he has used targeting China, the actions, again, the sort of at least unorthodox actions that have been taken with respect to China and targeting specific companies and doing all kinds of things that have really never been done before, that it is easier to kind of perhaps again rescind this or to modify it substantially and claim, look, we agree with the underlying concern, but we're going to do this differently because we just don't agree with the way it's been conceived. And I think that, and to your point also, I would expect that, I mean, we had heard rumors of various things kind of on this front. We had heard about something targeting Ant Financial and AliPay in the past. So this is not like completely out of the blue, but this, and at the same time, you would think that with the lessons that have been learned from WeChat and TikTok executive orders and the litigation there, that the ideas of have reasonable alternatives been considered, and has this been appropriately narrowly tailored, and have what is our response when they accuse us of inappropriately encroaching into the Berman Amendments territory and informational materials, and how is this actually regulating speech and all the other things like that. I would think those things have been thought through. Perhaps not, because
I wouldn't bet
sometimes
a nickel
obviously
on it
this is
right
a
now.
this is a shoot first, ask questions later kind of approach that this administration has taken on some of these issues. So maybe not, but but perhaps, I don't know. So, but I agree with you that I think there's a very good chance that we're never going to, it's not going to get to that point, and we're going to know it more in any event in about 3 or 4 weeks, I would think. By the time we get to day 30 or so, I think there will be sufficient pressure to have some kind of clarity as to what's going to happen here. Are we actually getting prohibitions, or is this going to go away, or is it, what's the case? So there's enough companies that have a skin in this that I think that will happen, much like what happened even with WeChat and TikTok, where there was some signaling that it was going to be kind of relatively narrowly tailored, and even there it was in some respects, but not enough, obviously, to hold up. So in any event, I think we'll know a lot more in about a month or so. I'm certain we're going to be coming back to this issue, but for now, we just kind of wanted to tee that up and give some initial thoughts. And with that, let's flip over to another one of the on the way out at the door parting shots at China, which we again started teasing the last time when it was still not certain this was coming, but the military end user list. So I'll throw that to Tim.
Sure. And we talked about this before as the phantom military end user list, because at the time, it had been leaked, or some version of it had been leaked, but there was some question about whether the final version was ever going to be issued, and turns out that it was. And now there is a list of military end users, and it's a list that is akin to the entity list. So essentially now there is and I guess we should back up just to review very quickly for those people who have not been following the discussion. Back last summer, the Commerce Department amended a regulation that restricts sales of certain U.S. origin goods to military end users, mostly in China, but also in Russia and Venezuela. And the definition of military end users is in part very straightforward because, when you think of a military end user, you think of the Army, Navy, Air Force, Marines, and those are included within the definition. But there is essentially a catch-all provision that was much broader and much more difficult to apply with respect to China, especially given what the U.S. views as the Chinese civilian military integration. So sometimes it's hard to tell whether a civilian facing organization has the exercises the functions and of at least some military functions, and if it does, whether it would fall within that definition. And so, since the change to the regulation, there has been a lot of confusion among U.S. businesses in determining what is a Chinese military end user, and a lot of calls for more guidance on this. And so, from one standpoint, the military end user list is designed to provide that sort of guidance. And so it essentially says, these entities are military end users, even though they're not within the traditional definition of a military, body. They don't look like the Army, Navy, Air Force, Marines, but we're telling you as the Commerce Department that they are on this list. So to the extent that it provides that sort of guidance, so much the better. But the problem is severalfold. One is it goes further than that. It puts them on a list that they are now automatically considered to be military end users for all purposes, meaning that they, sending goods to these companies requires a license. But one question is, okay, well, the licensing policy is a presumption of denial, but some of the guidance indicates that's not really the licensing policy, that it's essentially the license requirement is designed to check who's getting what, and in certain instances there will be licenses granted. So now that you have a customer on this list, should you seek a license? Is it a big waste of everybody's time? We don't really know. I mean, the words say yes, it is a waste of time, but some of the guidance suggests that it's not. And so there's more confusion. The list creates some confusion. It is a huge step in the sense that you now have to petition to get off the list. So not only are you if you're a Chinese company on this list, you're on this list and you're on this list forever until you can get yourself removed by the end user review committee, which is a pretty arduous process, as you and I both know. So it's a big step. It's kind of an unprecedented step. It's not, normally you would have thought that they would have provided this in the form of guidance, but instead they provided it in the form of an actual list that you need to be taken on and put off of, which is problematic in its own right. But then even in the form of guidance, they essentially say, just because you're not on this list doesn't mean you're not a military end user. And they're very clear about that, which means that, one of the things that I was hoping, if this list ever came out, was that you essentially, as a U.S. business, could engage in a presumption that the government didn't think that companies that weren't on this list were military end users. Now, if you have some special red flag reason to believe that your customer is a military end user, even though they're not on the list, then obviously they could fall within that catch-all definition. But you'd be pretty safe in presuming that if they're not on the list, they're not a military end user, unless you have evidence to the contrary. But the discussion in connection with the military end user list says exactly the opposite. This doesn't tell you anything about companies that aren't on the list. So it really doesn't provide much guidance at all with respect to those companies. And then with respect to the companies that are on the list, it's actually much worse than guidance. It creates extra impediments to doing business with those companies. And so it really is, it's almost guidance and a new rule, but in the form of a sanction and very little guidance at all.
Yeah, just a couple of quick thoughts. I think to me that is the big point, that this is a non-exhaustive list.
Yeah.
And even though creating a list like this has been done, and as is being styled as a good thing for the sake of clarity and for helping to help companies sort out who is and is not kind of on the naughty and the nice list here. To Tim's point, it is very clear if your customer or whomever you are exporting, re-exporting to is not on the list, you are still responsible for doing your own due diligence to determine yourself whether or not they may or may not be a military end user. So in terms of the burden that that places on exporters and others that are part of various supply chains that sort of feed into, in particular, China, but also Russia. That's a heavy burden and that's a lot of risk. And I think until there's some time passes and perhaps there's maybe a course of sort of a course of dealing and people get more comfortable perhaps in where they're how much due diligence is enough, where do you draw the lines, because as we've talked about before, the FAQs and other guidance on what is and is not part of that catch-all category is still pretty murky. Uh, I think it's just going to be a lot of line drawing exercises and a lot of internal memos trying to help justify kind of decision making and things like that. We're obviously part of that process with a number of our clients, and I think that's how people are going to have to proceed for the time being, which is not a great not a great place to be. On the other hand, when the US government is essentially taking the position that just about any company in China can be seen as being part of the civil military integration plan of the Chinese government, it's hard not to it's hard not to be uh, to exercise some caution and to be worried, right? So that's kind of where we find things, and that's kind of my big takeaway. I would also
Right.
just say, there from the sort of the leaked list that we had seen previously, that list was culled pretty significantly. I think there were well over 100 entities on that list. I think this is just over 100. It's about half. It's about 50-50 China and Russia, with a little more skewing toward China. And so, but again, to Tim's point, just like the entity list, I think we're going to be seeing on a regular basis, we'll be seeing new additions to this list over time. And so it'll be something that, for screening purposes and otherwise, companies are now going to have to build in. And we'll just have to see sort of how active this list is also under the new administration, because this is obviously something that was cooked up under the Trump administration and under his Commerce Department. So we'll see how active it is. I would suspect that, again, these are not the sort of civil military integration issue in China, concerns about sort of theft or diversion or misappropriation of U.S. technology and items subject to U.S. export controls for the Chinese military is not a new concern. That has been around for many, 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 many years. Again, it's sort of the execution. How do you get there? How do we actually achieve that? I think that is the big question. And so we'll see. Time will tell sort of what the new team does and how and whether this is a very active or becomes as active as the entity list has been the last couple of years. We'll see.
Yeah, I will say this. I think that, to me, the underlying message, after this change and all the changes from last summer, is that the military end user rule is still a mess. It is a complete mess. It's impossible to deal with from a U.S. Company exporter perspective, and I don't think this is going to be the last word on it. I'm not sure that we'll see the sort of repeal that we're talking about in connection with the executive order from the first segment, but I do think that, if it were up to me, if I were head of commerce for a day, which would be a disaster in so many other ways. What I would do is I would direct that this catch-all provision be rewritten to be more concrete, so that people could understand what it means and could comply with it in a way that is both kind of predictable but also makes sense from a national security perspective. Because right now, to me, that's the big problem, is that it's a catch-all so that anything could fit in it, and because anything could fit in it, from a compliance perspective, it just creates risk if you're selling to China.
Yeah. No. Well said. So while we all ponder what the Commerce Department would look like with Tim in charge, let's move on
Please
to
do not.
let's move on to topic number three, which is as we talked about on one of our last episodes of 2020. There's the new executive order that came out targeting Communist Chinese military companies and in particular publicly traded securities in those companies. As we touched upon when we first discussed this, I think there were a lot more questions that were raised by the executive order when it was first released, and there were many who were kind of clamoring for additional guidance, in particular. Because January 11th, which by the time this pod goes up, which will probably be on the 12th of January, January 11 is a key date there by which certain prohibitions go into effect. The wind down provisions for divestitures extend basically for the rest of this year into November. So I think that'll we're going to see a lot play out over the course of the next 10, 11 months during that time period. But there was certainly a lot of I think a widespread agreement in the trade nerd community, certainly, that there were a lot of questions that needed some answers. And so OFAC has tried to do that. They've issued now, I think it's 8 or 9 new FAQs just in the past couple of weeks. It's for anybody who hasn't seen these, it's FAQs 857 through 865. We're not going to go through in gruesome detail every one of these, but at a high level, they have covered the sort of some of the. I'll just kind of rattle through a couple of these topics quickly. So there was a question about subsidiaries of listed entities, and by the way, there is now a new list that you can find on the OFAC website, which is the NS-CCMC list, the non-SDN Communist Chinese Military Company list. So thankful for that we have yet another list to add to our endless string list of lists. And there was some questions about subsidiaries. Would the 50% rule apply? And essentially what the guidance says is that we are going to apply the principles of the 50% rule. We're also going to look at companies that are controlled by those that are listed, but the prohibitions do not go into effect until such companies are specifically listed, are publicly listed on this list. So those subsidiary considerations, they're sort of adhering to the 50% rule, but unlike with block parties with the SDN list, it doesn't automatically apply. They will have to be listed. That's the guidance there. There was also some questions about exact matches or close matches. OFAC very helpfully said, well, if it's an exact match or a close match, then it applies to that entity. So thank you for that. What is a close match exactly? I don't know. I'm sure there will be some. I'm sure there's going to be a lot of debating and hand wringing over that. There was some clarity on what is a publicly traded security, what's a financial instrument that's going to be covered. There were questions about applicability to exchange traded funds and mutual funds, and OFAC has now confirmed that ETFs and mutual funds that hold these publicly traded securities of these companies, these listed companies, are subject to these prohibitions for U.S. persons. So that's an important clarification. And then there was also some FAQs that dealt with facilitating divestiture of investments in these securities and support services that are permitted. And I think in some, without sort of getting into too much details there is quite a bit that U.S. persons can do in terms of facilitating divestitures and providing support services relating to trading or sales or purchases of these publicly traded securities. And again, the wind down, the sort of the divestment period that was laid out in the executive order goes through November of 2021. So there's going to be a lot more that plays out over the course of the next 10, 11 months here as many entities are trying to sort this out. I would also say there was some interest. There's also an interesting sort of related issue, which is the New York Stock Exchange has announced, they first announced they would be delisting 3 of these entities: China Mobile, China Telecom, and China Unicom, 3 of the largest Chinese telecom providers. Then they backtracked on that and said, no, we're not going to delist them. And then they flip-flopped and they said, no, we are going to delist them. and it's very clear they were conferring with OFAC about this the entire time. And maybe it looked for a while like perhaps they weren't going to delist. There was going to be some specific guidance on that, or they were going to get a license for that. But just a day or two ago now, they have gone back and said, no, as of January 11th, we're delisting them, those 3 entities. So that's all. The question I want, or the hot take that I have on this, brace yourself on this for this, Tim.
I'm waiting.
I throw it to you.
I'm bated breath.
I actually think that the FAQs that have been rolled out here are pretty good. That cover a lot of ground. That actually clarify a lot. So kudos to OFAC. We don't in fairness to our friends at OFAC and BIS and other places, again, we say it all the time. They're good, smart, hardworking people. We know they are doing their jobs as best they can in these trying, interesting times. I think here they actually did a pretty good job. Now, I'm not saying that every scenario has been covered, every question, every ambiguity by any stretch. I don't. For purposes of if we end up in front of a court litigating about fair notice, I am not conceding that we have fair notice of all elements of this executive order, but I do think this is a good start, at least, and so that's what I'll that's where I'll end my thoughts on that, and I'll kick it over to you.
So I will distinguish between the executive order itself, which is yet another attempt post-election to throw another complicated issue in terms of trade with China into the mix that has left a lot of people scratching their head. And the guidance, which I agree with you, Brian, is, a lot of the questions, or at least many of the questions that we had when this order came out, have been answered in a way that seems to make sense. Given what the executive order was designed to do, seems to make sense. The only other thing that I will say is, the zig and then zag of the New York Stock Exchange was really quite astounding to me, because I did puzzle over how it was that they thought that they could list a company in which U.S. persons could not invest. Now, I'm not sure why, the efficacy of such an order is in dispute to me, because it's really hard to say that these companies are going to be punished because you can't invest in their stock when they don't get a penny from any of these investments in their stock. I mean, they've already issued it; it's for sale on the public markets. But if in the long run, if it drives the price of their shares down, I guess it does punish them, although it doesn't punish them directly. But if the New York Stock Exchange was going to leave these companies on the list, from a compliance perspective, it just seemed like an utter nightmare to try and actually have a system where U.S. persons couldn't you couldn't sell to U.S. persons, and you would likely be facilitating transactions that violate the order if you sold to non-U.S. persons. Because the New York Stock Exchange is a U.S. person. If it engaged in transactions with non-U.S. persons involving the sales of these stock, they would seem to be doing something that a U.S. person themselves couldn't do, and so, or facilitating a transaction that a U.S. person couldn't themselves do. And so I just was astounded as to how they were going to continue to list these companies when U.S. persons couldn't invest in the stock, and how they would figure out who the buyer was, when generally that's not what a stock exchange would do, and that would leave it to the dealer brokers, who themselves don't have a lot of mechanisms for determining whether a U.S. person is involved in the purchase or sale of these securities. So I'm not surprised that ultimately they settled on the idea that they're going to have to delist these companies, but I still would love to know what made them think that they could keep these companies listed, despite their presence on the 13959 list.
Yeah, I mean, my speculation is that at least had they they must have gotten some indication from OFAC that perhaps it would not have been strictly required for them to do it. But I agree
Right.
with you. There's so many just sitting and spinning out the compliance nightmares that could come along with keeping those publicly listed on the NYSE. It makes my head hurt
Right.
just like thinking
Right.
about it
There's
for like
no
five
requirement.
seconds.
Right. There's
Right.
maybe they got that answer that you're not
Yeah.
required to delist. It's not. It's not in the order. They can leave
Right.
them on there, but they
Correct.
but they can't facilitate transactions in which U.S. persons purchase these investments.
Right. So that yeah. So yeah. So I don't know. I agree. I would love to have been a fly on the wall in those conversations, and maybe more will come out as to what drove the decision. But in any event, as of which will now be for anybody listening on the day we put this up will be yesterday. Those three giant Chinese telecoms will no longer be listed on the NYSE. So yeah, I agree with you. I guess as my one last thought before we move on to a non-China topic, to North Korea, is obviously there's been a lot of grumbling from China, very unhappy about this, not surprisingly. And to your point, it's another kind of post-election shot across the bow, poking the eye to China from this administration on the way out the door. And I wonder. I agree with you that I don't think, just like the MEU list, I don't think this is going away on come February or March after the new administration takes over. But I do wonder again whether there may be some modifications. There may be some perhaps openness to perhaps again executing this in a slightly different manner than what we've seen here, what we've seen to date. So again, I think with everything that has happened, certainly in the past year, but even especially in the past couple months, and especially relating to China, I think that's a question that everybody should be asking themselves as well. What do we expect? How do we expect this to be different, if at all? I think there's a good chance in many cases it will be done differently, even if the underlying authorities don't go away, even if the EO doesn't go away completely. I think there's a good chance we could see a bit of a change in tactics.
Yeah, I mean, look, there's a lot of things that have been put on the table in the last few months with respect to China, and they certainly, I don't think that the incoming Biden administration is necessarily invested in any of them, and though I think it probably agrees with some of the reasons, that at least the stated reasons, that these were put into place. And so some of them will stay, some of them will go, most likely, if there aren't other intervening events. But you could see these as potential bargaining chips in a negotiation with China, and certainly bargaining chips that could be substantially modified as part of a negotiated resolution of a lot of the outstanding issues between the two countries.
Yeah, no, I agree with that. Okay, so with that, let's go to our final topic, our only non-China topic, our only non-China, non-sedition topic of the day, which is North Korea. And for that, I'm going to turn to Tim to talk about a very interesting case in SDNY that had some activity in December that we wanted to touch upon.
Yeah, so we talked about this in one of the earlier episodes. Ethereum developer Virgil Griffith and his travels to North Korea, and apparently, I'm working from memory on this because I haven't gone back and reviewed the reports from the time. But my understanding was that Mr. Griffith was intending to travel to North Korea to speak at a conference on cryptocurrency, that he is an expert in cryptocurrency, and that he asked OFAC for permission and was told that he was not going to get to permission, and that he went anyway. And I think
I
we've
think he
talked.
I think he asked the State Department for a visa, and he didn't get
State
a
Department,
visa
right,
from the State
right,
Department.
because
Yeah,
right now there's no travel to North Korea because of the
correct.
visa provisions. So he's told no. Although the reason that I was thinking OFAC is that OFAC conversations have now come up in the case,
Yeah.
in the case involving Mr. Griffith in the SDNY. And so he went to North Korea anyway, spoke at the conference, and talked about cryptocurrency. And when he came back to the United States, he was arrested for traveling to North Korea, and is now charged with violating the North Korea sanctions. And one of the charges is based on the idea that his speaking at the conference essentially provided a service to North Korea. Um, he's moved to dismiss, and the motion to dismiss, I have to say, I found it much more compelling than I expected to. And the gist of the motion to dismiss appears to be that he provided no benefit to North Korea through his speech, because it was basically a crypto 101. It was information that was already in North Korea, so he wasn't providing anything new, and so therefore not providing a service. But also that, there is the Berman Amendment that we've talked about in connection with a lot of the restrictions on both TikTok and WeChat, under which the president doesn't have the power under IEPA to regulate the free flow of information under the guise of sanctions. And the argument of Mr. Griffith, again, that I thought was relatively compelling, assuming that these are the facts, is that going to a conference in a country and speaking about things that are already really a matter of public record in that country itself, does not seem to be providing a service to that country, nor does it seem to be something that would be within the scope of things that are allowed to be regulated under IEPA as a sanction. And so therefore, he didn't do anything wrong other than potentially violate the visa provisions, but certainly not the sanctions provisions related to North Korea.
Yeah, and the only thing he is charged in a one-count indictment with conspiracy to violate IEPA
Right.
by virtue of providing these prohibited services to North Korea. And I think exactly what you're hitting on is, as reported, and I haven't read the transcript of the hearing, but there was a hearing held by the judge in the matter in December, and it seems that the judge is also skeptical of whether or not this constitutes a service, what he did. And that, to me, those are the two most interesting aspects of the motion to dismiss, and I agree. I think it's quite compelling, and it'll be very interesting to see how this plays out. He basically says, look, I didn't provide a service at all. What I did was not a crime, period. And there's a number of reasons kind of cited for that. Tim has alluded to a number of them. There's some discussion in there about that it's not defined under the regs. The government counters by citing to the Iran regs and to Iran cases, and so we have potentially we have sort of an ExxonMobil fair notice issue potentially, but in a criminal case. So with an individual, so that dynamic is interesting. So that's one aspect of it, and then the other is again the Berman amendments and whether or not what he was doing or what just by going to this conference and speaking was what could be considered properly to be informational materials that were being conveyed. And the government, of course, takes exception with that and how that's defined and how OFAC defines that. And so we'll see. That's going to be probably a ways off before we get any kind of a ruling on this. Right now, I believe the trial is set for later this year. I think September was thrown around as the potential trial date. But I think that, again, one count indictment against an individual for something that I think he's making some very good arguments that if this is you're telling me this is willful violation of the North Korea sanctions, and I'm telling you that I'm telling you here that I don't even think what I did was a crime to begin with. I think that's setting up a very interesting juxtaposition, because I can't imagine that this is a case that's gonna I have a hard time seeing a plea coming in this case. So I think this is one that's either going to get, if he somehow prevails and gets it dismissed ahead of trial, that would be remarkable, and kudos to his lawyers, some of whom we know. And if not, then I think this is going to go to trial, and we're going to have another very interesting sort of example of how this plays out when the government and DOJ decide to really push the limits of how these statutes are interpreted. And I should add too, as another background matter, I noted that in the pending motions that were resolved or were before the judge in December, there was a request for OFAC related discovery, and that was granted. And if you recall, as we just discussed on the year-end pod last year, the solder case, that's exactly the same problem. That's what prompted all the problems there, is that there was OFAC discovery that did not get turned over, that was deemed to be Brady, and then once that thread got pulled, everything unraveled. And so here, I think because of the timing, it wasn't this tortured multi-year process, I would imagine, where prosecutors were going to OFAC and lobbying for them to do something, and OFAC said no, we're good. I think this all happened a lot more quickly, so the likelihood that there's sort of deep files from OFAC on how they viewed this and all the rest of it, I think, is probably less likely. But at the same time, because we're in the same district and because we're dealing with sort of a sufficiently kind of analogous situation, I'm very curious to see what comes out there. And I think obviously the government's going to have to tread very, very carefully in terms of its review of that material and making sure that they're not going to run into another buzzsaw like they did in solder by potentially not fulfilling their discovery obligations.
Well, that is what I was alluding to when I mentioned that OFAC is wrapped up in this, is that there is this discovery request that's been granted with respect to OFAC, which is exactly the solder scenario. And I suspect that the briefing, I haven't gone back and read it, but I suspect that the briefing focused heavily on what happened in the solder case as a ground for getting discovery on this issue. I think that there might be some stuff there, and I'll tell you what I think that it might be. The Berman Amendment doesn't just restrict, or doesn't just wall off from the sanctions programs informational materials. It also deals with travel, and so I suspect that the reason that the visa issue came out the way that it did is because while the Secretary of State can decide who gets a visa and whether they travel or not, but to do that in the context of sanctions, it's beyond the president's power, and so that there is no restriction on travel to North Korea from a sanctions standpoint. And so that's likely why there is no count that relates to the unauthorized travel to North Korea, because it's not sanctionable to travel to North Korea. And my guess is that there was some discussion about whether they could go after him for the travel, and perhaps OFAC said, "Hey, that's outside our authority, and so no, we can't."
Yeah, perhaps that would. Yeah, that's a good theory. We shall see. So anyway, we just thought that was an interesting. The case is kind of in an interesting posture and point right now. So we wanted to flag that, as there have been some news reports on that recently, and so I'm certain we will be coming back to that in a few months whenever we get rulings on the motion or the trial proceeds. So with that, we're wrapped up for the main portion of the show, and we will now proceed to the lightning round. The lightning round, our lightning round fully supports democratic principles 100%, just to be clear. So we're not an anti-democratic lightning round. So number one, two issues in the lightning round. Number one is a topic. These are both topics we've hit on in the past. Some updates and quick thoughts. So number one, we talked a few months ago about an interesting bit of litigation that was brought again in SDNY by a group known as the Open Society Justice Initiative and several individuals relating to the International Criminal Court executive order that was issued by 13928 that was issued last year, and the two individuals in particular that were designated under that EO and added to the SDN list. And I'm not going to rehash all the reasons for that. I think we've covered that pretty extensively in the past. But at the time when we saw the lawsuit, I think Tim and I both had some skepticism that they were going to be able to get traction in their efforts to potentially get a preliminary injunction. To what they essentially wanted to do was to be able to continue to assist and collaborate with these individuals at the ICC, because these are lawyers and policy experts who provide advice and guidance and legal briefing and other things like that bear upon the business of the ICC. And so they had said at the time, and I haven't gone back and looked fully, but I believe they had sought guidance from OFAC. They hadn't got it within a matter of a couple of weeks, and we said, well, of course they haven't gotten it within a matter of a couple of weeks. So instead they filed a lawsuit, and we said, well, maybe that'll get them their guidance, but prospects of success here seem low. Well, lo and behold, just a couple of days ago, they got a preliminary injunction that was granted. As to these individuals in this that are in this case. So it is narrow, and it is on First Amendment grounds. And so a number of the other grounds that were asserted are some of the same ones that we've been talking about now a lot recently, which is Fifth Amendment, IEPA, exceeding the bounds of IEPA because you're verging into Berman Amendment territory, APA violations, etc. Most of those essentially were found to be not ripe or no likelihood of success on the merits. But the First Amendment claim here was the grounds that the court found on. And interestingly, the court found that for First Amendment nerds out there, that strict scrutiny needed to apply because they viewed this as a content-based restriction on speech, because speech that supported these designated individuals at the ICC was regulated, but speech that was not be supportive of them was not regulated. I'm not 100% sure that I agree with that analysis, but the court in any event said, well, even if we were applying intermediate scrutiny, we would still come out the same way, essentially. So they kind of give that the back of the hand at the end of the day. But this is just a very interesting outcome. I don't know that we saw this one coming. Again, this is sort of, we're stacking up now court challenges that have been successful against IEPA-based authorities, which if you had asked me a year ago what the likelihood of success is generally when that's the case, very, very low. And maybe this is great lawyering. Maybe these are unique facts and circumstances. I think, as we've talked about a lot, some of the actions of the Trump administration are perhaps playing a little fast and loose with how the IEPA authority was used. And so maybe that's part of the reason here, is that they're getting out a bit over their skis on some of this. But I don't know. What are your thoughts on the PI in this ICC litigation?
So one good thing about 2020 and now the beginning of 2021 is we're seeing lots of fruitful litigation challenging IEPA authorities, which is also unprecedented. But you have unprecedented executive orders, you'll have some unprecedented results in litigation is the main thing that I read out of the litigation. And good for them. I mean, while we may have been somewhat skeptical of the chances in this particular litigation because of the way it was framed, I think we've always been very clear that this executive order is very problematic on many levels. It certainly from a policy standpoint, even if not from a legal standpoint. I think this might be the beginning of the end for that executive order, because I suspect that the Biden administration Justice Department may not be so anxious to defend an executive order that essentially sanctions the international criminal court, function. And while obviously they may not decide that the U.S. is going to join the International Criminal Court, I don't think that they will want to have a situation that exists currently where we're essentially enemies, and it is sanctionable to provide any support to the International Criminal Court. And so I think one way that this litigation could now settle is that it could become or become mooted, is that executive order were to go away, and this gives to the extent that there was already the will to do away with that executive order, this gives them a good justification. We withdrew it to prevent pending litigation in which we were losing.
Yeah, my initial prediction was that when the order came out, was that it might go unused essentially. I was proven wrong on that, obviously, but I think I'm right there with Tim that this might be one that is ripe for reassessment by DOJ and OFAC, and could very well go away at some point in the next few months. So we'll keep an eye on that generally, and on the litigation to see if there's any additional developments here. But with that, let's wrap up that initial issue and move on to lightning round topic number 2, which is one of our old favorites, Nord Stream 2 sanctions, and I'll throw that to Tim.
So, we've told the tale of Nord Stream 2 sanctions from, Section 232 of CATSA in 2017. And then I think in one of the first podcasts that we did, we talked about PISA which was, I think, adopted at the end of last year, maybe as part of the NDAA last year, but it was, another provision that sanctioned Nord Stream 2 directly, although it was very narrow. It was really the vessels that were essentially laying the pipes for Nord Stream 2, and not particularly effective, because by all accounts, those vessels kept working. And I think at the time we kind of joked that Russia might purchase all of these vessels and use them themselves because they didn't particularly care about sanctions. That is, by my understanding, of basically what happened. And so that sanctions program was not effective in stopping the completion of Nord Stream 2. And so in this NDAA, the PISA sanctions were essentially broadened to beyond vessels to all sorts of other activities in connection with the completion of Nord Stream 2. And at least from an initial read of media reports, these sanctions already appear to be more effective in deterring Western countries from working on the completion of the Nord Stream 2 pipeline. And so there's now some real concern as to whether it will be completed in the wake of these new sanctions that were really passed with the NDAA, which was not signed by the president. It was actually vetoed by the president, but that override happened at the very beginning of 2021. And so I think there are now some very muscular Nord Stream 2 sanctions in place that are extremely unpopular with our allies, or at least with Germany, and so I think it remains to be seen what a Biden administration will have to say in the face of this. Now, this is a law, so it's not like they can repeal it, and certainly they will faithfully execute it. But it does, like the CATSA provision originally, it does have some language in it that suggests that that the U.S. government consult with our allies on this. And if we consult with Germany, I suspect that I know how that conversation will go. And so I certainly could see the possibility of some of the waiver provisions being exercised in a Biden administration if they are on this kind of rebuilding tour with the allies, and this shows up on Germany's wish list. But I think that remains to be seen, because I can think of a lot of reasons why a provision that just mustered enough support in Congress to override a presidential veto. And granted, it was part of the NDAA, so it's not like this provision alone mustered that level of support, but it's certainly not. We got into the NDAA would suggest that it did have a high level of support in Congress. I will be surprised if a president, a new president comes in and decides that that is not something that he wants to enforce. But I also think that there are some diplomatic reasons why this is going to be a tricky issue for the Biden administration to navigate coming in. But it does seem like it might prevent the completion of Nord Stream 2, which the earlier sanctions have not.
Yeah, I just a couple quick thoughts on that. I think so there was a report that came out a day or two after the passage of the new law and the expanded sanctions that a Norwegian-based company that had been contracted to perform pipeline integrity verification services, which is, I think, pretty squarely within the scope of the newly added bases for the sanctions, has said that they are going to cease performance of that conduct with respect to Nord Stream 2. So right there, somebody walking away, and there have been reports of this kind of when the PISA sanctions were passed in the past, but that was pretty notable. And I also saw a report that there's the remainder of the work to be done here is largely in German and Danish waters. They were originally estimating it probably only required a few more months of work. Now they're pushing that out to maybe by late this year it'll be done. Again, I think that's not quite factoring in fully what the impact of the sanctions here will be, and how many companies may be scared away, and how long it might take to find substitute companies that'll come in and perform. Because I agree with Tim. I think I am still skeptical that this is ultimately going to stop the final construction of the pipeline. It may delay, and I think this also just rolls into one other big question, which is, because this is all ultimately about Russia and about energy security, and their sort of dominion over Europe's energy security by virtue of their role in the pipeline. We've asked the question, what is the new administration going to do with respect to Russia, when obviously the current administration didn't, Russia was a dirty word. Nobody wanted to hear about Russia. I think the opposite is going to be true here, which is I think we would expect much more aggressive action to counteract Russian malign influence and Russian, whether in Europe or here domestically. And so I think that's just a bigger question that this kind of feeds into. So I think this kind of tees up nicely, again, like what will the new administration do with respect to Russia? And I think this will be part of it, or the Nord Stream 2 certainly project generally will be part of it. And so we'll just have to stay tuned for that. But
Yeah, I totally agree. I just think this one is a little more tricky than just the general Russia issue, because I think generally the allies are aligned with respect to certainly what Russia has done in Ukraine, and the need to push back against that. But I think that one of our allies in particular, Germany, is very, very feels very, very differently about Nord Stream 2, and so it's going to be a tough one for President Biden to navigate.
Yeah, assuming there's some sort of a perfunctory welcome congratulations call that happens shortly after Inauguration Day between President Biden and Chancellor Merkel, I am certain this will be on the agenda. This will be a talking point for her side. So yeah, that's exactly right. So we'll see. But in any event, that concludes the lightning round. That concludes our very first episode of 2021 for Embargoed. We've made it through. We made it through 2020. We made it through the first week of 2021. We will see if we can make it through the next 12 days to get to Inauguration Day.
No one stormed the podcast.
No one stormed our podcast studio, which is, and that's for me and Tim and our producer Matt. So thank you to our loyal listeners there. And so thank you to everybody again for tuning in, as always. Again, we appreciate you listening, appreciate the support. Please subscribe if you have not already. We will be back in 2 weeks. So the next episode we will probably record right after Inauguration Day, the Thursday or Friday of that week. And so the next one will be up kind of the end of January, toward the end of January. And who knows what we're going to have to be talking about at that time. I suspect more China, but we will hold our breaths and keep our fingers crossed that there's not something more serious to talk about than that. So for everybody out there, just thanks again. Happy New Year's, and until next time, stay safe and stay sanctions free.
Stay sanctions free, everybody.
Thanks, everyone. Bye.